this guy's garage. Like and subscribe.
Welcome to you all.
And we have Arun Bangaraj, the Deputy Minister of Transport, here with us too.
We could not have a meeting without mentioning his presence in the back. So welcome to you, sir. Thank you very much, ministers, for your opening remarks. We'll begin our line of questioning today with Mr. Lawrence. Mr. Lawrence, the floor is yours. You have 6 minutes, sir.
Thank you, Chair, and thank you to the ministers for agreeing to be here for the next 6 hours. We appreciate that. No? A little fun to begin with here, guys. You can smile here. So Conservatives agree directionally that, of course, we need national projects built. We need the elimination of interprovincial trade barriers. In fact, over the last 10 years, the old Liberal government was very much against that, we felt. We are glad that the new government appears at least open and directionally. But we do have some concerns, particularly on the ethics, accountability, and transparency side. And I'll start by referencing sections 21, 22, and 23 of the Building Canada Act. When these sections are combined together, what they have the ability to do is give a minister the ability to exempt any national project from any piece of legislation passed since 1867, with the exception of the Charter of Rights and Freedoms. Given that, and given the fact that the Prime Minister worked for one of the largest constructions and manufacturers of national projects, of infrastructure in Canada and perhaps in the world, in Brookfield, could you please identify to us the screens that we put in place to make sure that we don't have conflicts of interest or other lobbying concerns?
Well, Mr. Chair, perhaps I could, and thank you for the question, Mr. Lawrence. It's a good question. And you're right when you identified the operation of those particular sections. In no discussions that I was in or that I participated in was exempting requirements under the Conflict of Interest and Ethics Act, for example, would be a piece of legislation that obviously you're referring to. As the minister who would be designated as responsible for this act, I can't imagine that in the course of my recommendation to Cabinet, that would be the kind of exemption that we're looking at. But I'm obviously would, in any circumstance, be governed by the advice that we would get from officials from the Privy Council office and the Ethics Commissioner in those circumstances. I get the hypothetical question you're asking, and I've seen you and your colleagues raise these concerns in different fora elsewhere. I just think it feels very hypothetical that we would be approving a national project and look to exempt responsibilities of any member of Parliament or public office holder, member of Cabinet from the ethics obligations. I wouldn't ever do that myself. I wouldn't go to Cabinet with that kind of recommendation, but I take your point.
Thank you, Minister. Well, I would follow the old Ronald Reagan quote of the "I trust but verify," and it is striking that the way that 21, 22, and 23 work together in the Building Canada is literally any legislation can be exempt, including the Conflict of Interest Act, the Lobbying Act, the Income Tax Act, the Criminal Code. And while I certainly want to trust, I would also like to verify. So my question would you be open to an amendment that would restrict that to prevent exemption from the Conflict of Interest Act and other acts?
Again, Mr. Lawrence, thank you for the question. And the Deputy Clerk, because as I say, it is a good question, and I wouldn't want to leave an impression that is inaccurate. And perhaps Chris Fox could add something if, in my explanation, it's not as precise as it should be. There are limits in terms of what acts or what exemptions could be issued. In Part 1, it talks about Acts of Parliament, Fisheries Act, Indian Act, International River Improvements Act, National Capital Act, Navigable Waters Protection Act, Migratory Birds Convention. It doesn't speak of some of the ethics obligations, the criminal code.
If I could just...
It speaks, and again, because your question is a good one, I don't.
Yeah.
Again, I've hypothetical question, we're going to approve or designate a project and exempt it from the Criminal Code of Canada, doesn't feel like, I just don't want, doesn't seem like a legitimate line of questioning.
No, and I appreciate that, but the Act actually says in 21 you can add other acts to it, which means you could, in theory, add the Criminal Code. I'm not saying you would, Minister. I'm saying that the possibility there too exists, and we have seen in the old Liberal government that we've seen some ethical lapses, and so I know, shocking, and so we would be looking for an amendment to make sure, and specifically, like I said, the Prime Minister, of course, worked for one of the largest infrastructure, or ran one of the largest infrastructure companies in the world, and so putting those screens in place, I think, are incredibly important. Would you have any details on how the Prime Minister screens might be put in place to make sure we don't have conflicts of interest?
The Prime Minister has answered the questions, and the Ethics Commissioner's office is able to talk about all the screens that are appropriately in place to ensure that there is, in fact, no conflict of interest or appearance thereof. I'm not sure that any of us are going to speak to those specific ethics provisions, but perhaps Sarah, can you add something?
Yes, just on the controls that are in place with relation to 21-22. So yes, on the recommendation of the designated minister, the GIC could add acts and regulations. That's needs to be done with respect to the purpose of the Act, which is to advance national interest projects, provide environmental protection, respect Indigenous rights. So it needs to be in keeping with the purpose of the Act, first of all. And then the regulations under Section 22 would need to actually be on the recommendation of the minister responsible for each of those acts. So the Minister of Fisheries and Oceans, if modifications were being made to the application of the Fisheries Act. So that's another control that's in place.
Thank you.
They're also subject to Statutory Instruments Act regulatory process.
Thank you very much, Ms. Jackson, and thank you, Mr. Lawrence.
I think it's really a shame that we don't have the opportunity to properly, thoroughly study the bill. There are countless people who would have liked to testify today, but who will not be able to. And we will not give this bill the fulsome study that it warrants. The government is acting with a sense of urgency, I believe. Otherwise, the government wouldn't be proceeding quite so quickly. First question, is this not a disguised version of the Emergency Measures Act? That's what a constitutionalist wondered yesterday, and wondering what your thoughts are on that. Thank you, Mr. Chair, and through you, I thank the Bloc Québécois member for his question. I don't share that interpretation of the situation. The Emergency Act is only applied when there are specific legal conditions met. I participated in deciding to invoke the Emergency Act the last time, and I'm proud of the decision we made. It was the right one. It all depends on the context. Now, during the campaign, this was discussed, and we also discussed it in Kananaskis. Thank you very much, Minister. Yes, but I was going to describe the situation of emergency or urgence. You said that this is not akin to the Emergency Measures Act. Next question, then. There's a sunset clause that says that in 5 years we will no longer be able to apply it. So you're granting that power, and you're allowing people to flout basically any existing legislation. So if things are not urgent, then why are we granting such extraordinary powers? Answer, you interrupted me when I was trying to explain why this is urgent. This is urgent from an economic standpoint. There is a great deal of threat from the United States. During the campaign, we often discussed how important it is to build nation-building projects which are deemed to be in the national interest. We discussed that with provincial and territorial premiers at our recent meeting in Saskatoon. We need to move to take action to diversify international trade. We also need to expand clean energy, and the government of Quebec. That's the context. That's why it's urgent. Question, but are you not taking this notion of urgent or emergency situation a bit too far. This is being seen in other countries. People are going too far. We don't want the Emergency Measures Act to be invoked left, right, and centre. We don't want that to be the new trend. Is that what you're doing? Answer, no, that's not what we're doing. We cannot compare this legislation to a White House presidential order. That's an inaccurate comparison. You can see things however you see fit, but I disagree. Question. Now, you are granting people the authority to approve projects based on consultations. They might be phony or sham consultations. There won't be any criteria for you to use to approve projects because the criteria will just be suggestions. They won't be mandatory. And you will be the ones to choose the conditions that projects will be submitted to. Answer. I won't correct you necessarily, but you said there are no criteria for the selection of national interest projects. Well, my colleague did enumerate the SANC criteria contained in the bill. As my colleague explained, we might some say that we might hypothetically be able to sidestep any and every existing law. That is inaccurate. If the bill passes, this will be a process. It will go through the Governor and Council. You are exaggerating. You're really exaggerating. Question. But you will not be bound to respect sections 5 and 6 of the bill. Next, the Prime Minister, your party leader, promised that there would not be any projects without Quebec's explicit agreement. Your party leader promised us that during the election campaign, yet we don't see any trace of that in the bill. Do you intend to uphold that promise? Answer. I stood beside the Prime Minister at a press conference. The press conference when he said that we won't impose projects on provinces, but that's not in the bill. Would you state this explicitly, this promise, this commitment in the bill? Answer. I'm not a member of this committee. I'm happy to be here with you for 2 hours, not 6 hours, but I won't be here for clause by clause. Yes, but this is your government's legislation. This is really just crying wolf. You're saying, well, things are very urgent and we're going to act in your best interest, but we don't know that you will act in our best interest. You don't often participate in federal, provincial, territorial meetings, but I was there in Saskatoon meeting with the 13 provincial and territorial premiers who were elected to represent their jurisdictions. They all decided that we needed to move in this direction. You are describing some hypothetical case which could maybe happen. Yes, hypothetical though, hypothetical. That means it could happen by government order. Thank you, Mr. Speaker.
You have 5 minutes, please.
Thanks, Chair. Appreciate it. Thanks you, ministers, for being here. And just to follow up, to conclude on what my colleague Phil Lawrence was asking, so just is it safe to say that neither of the three ministers here are responsible for the bill, and no accusation towards you in general, but neither of you are aware of or have seen or know about a concrete ethical screen in place for the Prime Minister? Okay, I'll just take that as a no. So let's.
These things are properly done by the Ethics Commissioner and the Deputy Clerk.
For the bill.
Ms. Fox, did you want to respond to that?
I just wanted to state quite clearly that at the Privy Council office, we are working very closely with the Prime Minister's office to manage all of the conflicts that he's declared, and that is operationalized within the communications between the Privy Council office and the Prime Minister's office, and that would be
Okay,
linked
thank
to
you. So-
anything, including this bill.
Thank you. So you may be aware, but that it is clear then that the ministers responsible aren't, but so Canadians will trust you on that. So given that this whole concept, this whole bill started in the election campaign with meetings with the premiers and the territorial leaders, there's been weeks since those meetings, weeks since parliaments have started. Is it possible, since there seems to be mixed messages about politicians sending lists in and not, is it possible for either of the ministers to identify a single energy project, for example, that will be approved and ready for shovels in the ground in June 2027 if this law passes by this week?
So, Mr. Chair, through you, Ms. Stubbs, a very good question. Obviously, we don't want to prejudge whether Parliament will adopt this legislation. We're hopeful. And then we're also hopeful based on, I sat Monday night and had dinner at a table with the Premier of Alberta and had a long conversation with the Premier of Saskatchewan. They are very enthusiastic about putting quickly before the Government of Canada projects that, in their view, and probably in our view, would meet the national interest test. So I think we're going to be very fortunate by the volume of projects that will come together quickly. But, and I think this is instructive, this isn't a federal infrastructure program as much as it's a way to expedite projects that provinces and territories, Indigenous partners, private sector proponents will want us to work on in an expedited, effective way that encourages investment decisions. So I think we'll have well more than one within the first 2 years, but you can imagine, I don't want to prejudge what will be submitted.
Yes, and certainly we Conservatives will join you in your hopes and prayers, but obviously would have hoped for something a little more concrete. Because, of course, as you know, and I might suggest this is a first place for you all to stop, there are dozens of projects with real proponents spending real money, losing real time, stuck in the federal regulatory process, stuck in front of all of these various pieces of legislation and regulations that now you yourselves are identifying are barriers to getting built. That's why you're bringing in C5 to fast track these projects. I just would suggest maybe you want to start there with the real proponents of real projects stuck in front of your regulatory mess right now and give them some certainty. But to that end, can I ask you, how is it that the lack of the 2-year timeline embedded right in the legislation, including criteria and conditions that will be made behind closed doors, and then where projects will be adjudicated on an ad hoc, case-by-case basis. How do those two embedded uncertainty, not yet addressed in the bill, but we hope you'll accept some amendments in that regard, possibly give private sector investors or proponents that want to get these big, major nation-building projects to the benefit of all of us built? How does that lack of certainty in this bill give them certainty?
If I may, Ms. Stubbs, I want to start where Mr. Lawrence began, that a lot of us here are in violent agreement about the objective and that we do need to get big things built faster in Canada.
Certainly, and because you yourself announced that in 2022, and of course now.
And what I would just say is that there is a contradiction between the notion that specific projects should be named right now and the path we need to take to actually get things done. This legislation, quite intentionally, is about setting a framework which is clear, which is transparent, which gives transparency to provinces, to Indigenous organizations, to business leaders. And we need to sort of go step by step. We need to have the framework, have the transparency, hopefully get the legislation passed. As my colleague has said, there are a lot of projects waiting for this. We were together in Saskatoon, we heard from the premiers. They are very, very keen, but it would be inappropriate to actually specify the projects in the legislation. The right way to do it is create a framework, be having the conversations, and then let me tell you, as soon as this is passed, we're going to be moving with alacrity.
So what would you have to say to all the projects who will not be fast-tracked or make the cut?
Sorry, Ms. Stubbs. We'll move on now to Mr. Kellaway. Mr. Kellaway, the floor is yours.
These bills have to respect current statutes. Sometimes they don't necessarily require consultations, but here we're going to have big projects that will have big impacts that will often require society-level discussions because it will engage generations. And this would be subject to fewer acts than small projects that are being done by SMEs. So what we have at the end of the day is a series of decisions that will be made behind closed doors where there will be a politicization of decisions, and nothing guarantees that you won't transform yourself into the Minister of Cronyism. The Association of New Brunswick Acadians contacted us to say that they were worried because the Act would allow to ignore all other acts like the Official Languages Act. They could not have to take into account the Labour Code for these projects. So to me, that's a problem. You already have all the powers to ignore environmental projects through the projects that will be submitted. Why do you want even more powers that you don't need for these projects to move forwards? Through you, Mr. Chair, Mr. Barcelou Duval has asked about 10 questions in one, so I'm going to do my best. First of all, I would like to encourage you to not continue under the idea that we can exempt a project from the Criminal Code or the Official Languages Act. Privy Council experts have told us, and there will be no doubt legal experts appearing here, the decision must be made pursuant to statutes and pursuant to conditions in C5. So if we want an entrepreneur who doesn't want French or any French signage, it'll be the objectives of the bill that will be targeted. If someone doesn't want to pay bills, they could be targeted. If they don't want to pay a tax bill, they could be targeted. It's so broad that you could almost do anything. What acts, not in the 7 regulations, 13 acts in Schedule 1, will also be exempted from projects? Why not say it now? By talking about anything, you sound distracted because you're using completely ridiculous examples to try and make a point that makes no sense. You also mentioned that these projects will be, these national interest projects will be subjected to less oversight. Please allow the Minister to answer, and then we'll move on to our next questioner. The Minister says that what I say is ridiculous, but if I look at the document, it exempts projects from any act. Any act. I'd like to ask the Minister to answer. We can move on to someone else. It would be better.
Mr. Albus, the floor is yours. You have 5 minutes, sir.
Thank you, Mr. Chair. Thank you, ministers, for your service to the country and for being here. Hopefully we'll get some accountability. Minister Freeland, there was some reference to freeing the beer, going between provinces. Really, under this act, there is nothing because if a province like BC and Alberta come up with a bilateral between the two, all it does is, this bill says that you'll just acknowledge it, recognize it, but it doesn't add any value. Is that the case?
I was very careful, Mr. Albus, in my comments, not to overstate the specific contribution this legislation will make to internal trade and labour mobility. As you know very well, the federal government's role in that space is limited. What this is about doing is the federal government doing everything appropriately within our power to contribute to the larger goal of free movement of goods, services, and people across the country. And we need to do this because it's very hard for the federal government to play the appropriate role of convener of provinces and territories if we're not doing our part.
Provincial shipping is actually a federal power, Minister. The Canada Post Act, for example, I had a bill C-260 that would actually give Canada Post the authorization to send beer, wine, and spirits. Right now, it's something that can be prohibited by an individual province. That is a federal power. Moving on, it's in the Act here, it also says that you will recognize a designation or a credential from a provincial. At the technical briefing, the bureaucrats that were there, good people, mentioned that surveying, land surveyor, for example, might be. Are there any other jobs that this would apply to, or is this just so niche that it really doesn't do very much?
I've been very clear not to overstate the extent to which the federal government is our problem when it comes to barriers to interprovincial trade, movement of goods, services, and people. The fact is, this is principally a provincial matter. This law is about the federal government doing our part. There are a few specific areas that this legislation removes unilaterally, because what we're saying to the provinces and territories is this is a national effort. And I made a point in my remarks to highlight the excellent work that is being done by provinces and territories right now, because they are leading the charge. We need to salute their work. We as federal MPs collectively have a responsibility to support what they're doing, for the federal government to do our part. And I also want to be very clear. This legislation is very important when it comes to internal trade and labor mobility. It is not the end of the process, and we all have a responsibility to keep going, to support the provinces, to have truly free internal trade.
A previous Liberal Prime Minister used to say the dangers about being the head waiters to the provinces, and it seems that that's all you guys want to talk about is provinces, territories, but national interest, by its definition, has to reign over provincial interest. So, for example, the Prime Minister has said publicly that that premiers have a veto, like David Eby has said he will not support a pipeline to the Pacific, even though it would be in our national interest to get our energy to other markets. Minister, is there a national interest here, or are you only serving up for the provinces?
I am so happy that right now this is a moment of a degree of national unity and consensus around this effort of a kind I have never seen before. That meeting in Saskatoon, a province, as we know, which has a conservative government, was a meeting with more unity around free interprovincial trade and getting major projects built than any meeting of provinces, territories, and the federal government I have been present at. And so, Mr. Albus, I see no benefit and a great deal of harm at this moment when the provinces are all stepping up in the federal government somehow saying, we're going to push you guys around. The fact is, we don't need to. The provinces are doing a great job.
This is why we have a prime minister and a federal cabinet, is to decide what the national interest is. That actually is your job. But besides that, I would just go back. I'd like just to go to Minister LeBlanc.
Our job in the national interest, in fact, is to work collaboratively with provinces and territories where we can. It's
either a crisis or it's not, Minister. It's either an emergency or it's not.
Honey can be better than vinegar sometimes in building consensus.
I would like to see a list.
And right now, that's what's happening.
I would like to see a list,
believe even
Minister,
the Conservatives are voting for this legislation.
Coming from my federal government.
And I'm happy about that too.
Section 21, 22, and 23 operates to allow any project to be exempt from this legislation. Mr. Bassam-Duval suggested that this legislation was similar to the Emergencies Act. I'm seeking some clarity on your answer, Minister LeBlanc, regarding because notwithstanding the validity of a law, Section 21, 22, and 23 of Bill C-5 allows a project to be exempt from the legislation. And we have seen sweeping powers in the notwithstanding clause in Section 33 of the Constitution that allows the suspension of liberties, but there is a provision that protects citizens under Section 1, which is the reasonable limits. Where's the reasonable limits of this legislation? Where's the breaks in this legislation so that federal governments don't become bullies and sweep into municipal and provincial jurisdiction like they did with Bill C-69?
So, Mr. Chair, through you, Dr. Lewis, thank you for the question. I think it's important. The reason the government has put this bill before Parliament is precisely to enable large projects in the national interest to be built. I think that the context and the purpose of the legislation, there's part one, which speaks about free trade within Canada. The part with respect to major projects focuses on enabling. And this is enabling legislation that creates a framework for these projects to be advanced. So, people often refer to the clauses, Dr. Lewis, that you properly raised. any exercise of authority in that context has to be done with respect to the purpose of the legislation. So if the purpose of the legislation is to enable these large projects to be built, you can imagine a series of statutes that may form part of that evaluation, and then it's exercised by the governor and council, which is not an unusual process.
My question specifically, though, doesn't deal with the enabling aspect of the legislation. We know what the legislation is about, but my question is specifically, what do you, Minister, see as reasonable limits on these sweeping powers that allow the invalidation of laws pursuant to Section 21, 22, and 23 of Bill C-5? Where are the reasonable limits? What do you see as reasonable limits? And why aren't they contained in this bill?
Well, so, again, the reasonable, I think it's important, first of all, to put it in context. These decisions will be exercised in consultation with provincial and territorial leaders. The proponents of the projects, I'm encouraged by premiers working together to create, for example, energy corridors. The proponents in many cases may be sovereign provincial and territorial governments with Indigenous partners. So that is a limitation. That is a limitation in and of itself. We'll be designating projects that have gone through the scrutiny of other orders of government, for example.
But, Minister, yesterday we heard concerns from a number of stakeholders and constitutional experts who confirmed that this bill is vague, has been hastily written, and leaves much uncertainty with respect to projects of national interest. In fact, that determination, it was concluded that that determination would be solely a political decision, which, given these provisions in Section 21 and 22, leaves room for political abuse. And my question, I'm turning back to the question, is where are the breaks in this legislation, and why are there no reasonable limits put in this legislation so that this government can evoke the confidence of the people?
Dr. Lewis, if I may, seeking to understand the roots of your concern, I guess I'd like to understand whether you are concerned that as a result of this legislation, we will build too much. Whether as a result of this legislation, we will get too many major projects built.
Excuse me, I think that is actually a very pejorative way of characterizing my concern. And Canadians are concerned, and I don't want you to minimize Canadians' concern about building too much. That's very facetious, and it's unnecessary. We're trying to help, and we had witnesses yesterday that were very concerned about the about the liberties that will be suspended in this legislation, and you're making a joke out of it. It's not funny.
No,
it is not funny.
No, truly, I was in no way making a joke. I was being entirely serious. This legislation is being proposed by us, and I believe it is being supported by the Conservatives, because there is a national consensus, which I believe many Conservative MPs agree with, that we have come to a place in Canada where we have such a thicket of processes and rules and regulations at all levels of government that we are unable to build with the alacrity that this moment in time requires. This legislation addresses precisely that realization, and that's why it creates a clear framework to consider and put forward projects of national interest. There is going to be great transparency in terms of which are the projects being put forward. There is a specified list of the areas where the legislation may need to move with more alacrity. And I'm very sympathetic, as I believe my colleagues are, to concerns around protecting due process, protecting the rights of Canadians. Absolutely.
Thank you.
But I'm very confident this legislation will in no way infringe on rights and will do something that Canadians have a right to, which is to build Canada.
Thank you
Mr.
very much, Minister.
I'd like the record to show that my question was not answered.
Thank you, Dr. Lewis.
Thank you.
Next, we'll turn the floor over to Ms. Gazan for 5 minutes. The floor is yours.
Thank you so much, Chair, and thanks to the committee for letting me ask questions. My first question is for you, Minister Alty. Article 19 of UNDRIP provides that states need to seek and obtain free, prior, and informed consent of Indigenous peoples before adopting every legislative measure. Has the federal government upheld this obligation with Bill C-5? Yes or no? Just because I have very limited time. I'm an independent now.
Yeah, thank you. Thank you for the question. So this process has been an accelerated process for the legislation.
So
however,
just because
the key
I have
is,
5 minutes, so the answer is no. It's accelerated, so no, it hasn't. I'm going to answer for you because
the key is though that for the legislation, the consultation is happening on projects to be added to Schedule 1.
So I'm talking about this, sorry,
projects.
Minister, I'm talking about this legislation specifically because I'm sure you're aware that nations that have signed modern treaty agreements should have been consulted before the bill was tabled. That did not happen. Do you believe the advisory circle fulfills the constitutional requirement to consult and accommodate and contain full consent of Indigenous peoples, yes or no?
As mentioned before, the Indigenous Advisory Council is providing guidance to the Major National Projects Office. However, the consultation on projects to add to Schedule 1, as well as if a project's added, the consultation on conditions has to be done with the Indigenous rights holders,
right,
which isn't the Indigenous
So
Advisory
you agree
Council.
with me that the advisory circle is not an Indigenous rights holder?
Correct.
Okay, well, that's very good. So I have a question. If Quebec says no to a pipeline, I think this would be for you, Minister. If Quebec says no to a pipeline, would you respect that? Yes or no?
The Prime Minister has been clear that he does not see us using this legislation to impose a project over the objection of a province.
Great. Thank you, Minister. Moving to you, Minister Attlee. If Indigenous peoples say no to a pipeline, will that same principle apply? Yes or no?
Yeah, and I think the key thing for this bill is really looking at, the bill is about looking for projects that are urgent.
So just because I have questions follow up. So I just want to be clear. So if Indigenous people say no, I don't want a pipeline,
that's
the
part
same
of,
principle would apply, yes or no?
Yes, and so what I was gonna explain for this bill is that we're looking for projects with urgency.
And you've explained that,
as
and that's
well as
already on
advancing-
record. So I just because
I haven't explained that part though.
So what is
Excuse
your
me,
understanding?
what I'll do
we
is
do
I'll
wanna
promise to give you an
find-
extra 30 seconds.
Okay, thank you.
Just to make sure
I
that
have
the
5
minister can
minutes.
respond to your
Okay.
question.
Yeah, because I do think
Rebecca
it's important that you take a look at the legislation, and it is about evaluating projects that have a high likelihood of successful execution and advancing the interest of Indigenous peoples.
Yes.
And so if projects are being brought forward that don't meet those conditions, we're not going to be able to move with urgency as a federal government.
Sure.
And so we're looking for the high likelihood. We're not looking for Schedule 1 to have 500
Sure.
projects, because the more projects we have, we want
Can
that white glove
Can
service.
I move on now? So you said, you gave 5 criteria, and I want to read this. It says, in deciding whether to make an order under subsection 1 or 4 in respect of a project, the governor and council may consider any factor, the governor and council, the words are very important, that the governor and council considers relevant, and D, I want to speak specifically to D, advance the interests of Indigenous peoples. Do you think it's appropriate that the governor and council make the decision on behalf of Indigenous people of what's advancing their interests, or do you think Indigenous people should be making those decisions themselves? Because it's very clear in here, and this is a concern that's been brought up by many Indigenous groups.
Yeah, and the key is the consultation would involve the Indigenous rights holders who may be impacted. So the consultation and accommodation would be with the Indigenous rights holders.
So would you agree that this probably needs some amendment?
It's actually section 5.6 7 that's got, is it 5.7 that has...
So just while we're waiting.
Ms. Kazan, the time is up. I'm going to let the minister look to respond.
Sure.
Just want to make sure she has a moment to look that up and respond to your question.
The, 5.7, the consultation, page 10. Yeah.
I'd like to come back to what the minister said, saying that I was just talking rubbish, but I would ask him to read the communiqué published by the Acadian Association of New Brunswick that have concerns about this bill and their rights, and go tell them that their preoccupations are absolute rubbish. What is rubbish are the extreme powers that you want to grant yourself through this bill that need to be controlled, that need to be studied, because this bill is not ready to be adopted in its current form. The question I have for you, Minister, I talked about emergency measures. You said it's not a hidden Emergency Measures Act, but there is a sunset clause, and there's also another characteristic. You want to adopt it rapidly, and you give power to the executive that used to be regulated by legislation. Why a sunset clause? Will there be no emergencies in 5 years? We tabled the bill in a context of economic emergency. My colleagues described our concerns with regards to the diversification of the Canadian economy and with national interest projects that could increase Canada's GNP. We are faced with global uncertainty. Economically speaking, there are tariffs from the States. These are all tied together. And that's why we are in an emergency. During the election campaign, Prime Minister Carney was very clear. He said that he would work with our government and provinces so that everyone has to work together. Thank you. It seems that you're giving yourself emergency powers far excessive of what would be reasonable. So I believe this is going to end up in front of the courts. I believe that your bill will be contested in the future. Your bill also allows you to tailor acts that do not apply for a project. So you can negotiate with an entrepreneur what acts will actually be they will actually be subject to. So what are the guarantees that there won't be any corruption under this? I'm not saying that you're corrupted, of course. I'm not saying that you're corrupt. I'm not saying that you're going to cancel the Official Languages Act for big projects. What I'm saying is that this bill allows that to be picked and chosen in the future. Of course, Mr. Barcelou-Duval, I do not agree that this bill opens the door to corruption. I would not want to be associated with such a sentiment. Nevertheless, you are right in so much as we've identified an economic emergency that was shared by premiers of the provinces and territories, and we now offer a new way to move forward for a limited period of time so that we can be more coherent in our way to move forward when projects are deemed to be in the national interest. Designated projects, and the other thing that we don't have to, or the other myth that we have to dispel, is that this will be done without transparency. The designated projects will be designated in a transparent way. The conditions attached to the approval process will also be published through Order in Council. You have no obligation to be transparent. There's almost no countermeasure. The only measure of transparency that you mention is what will be in Schedule 1 and Schedule 2. To me, that's not very transparent. We'll use these powers when Parliament isn't sitting. There is a provision for this transparency, Mr. Barcelou-Duval, and in your preamble, in the preamble to your question, you said that normally this is a power that is designated upon the legislative authority. What we are saying in this case is that the Environmental Assessment Act, the Fisheries Act, all these analyses will happen, but will happen in a more coherent way, in an expedited way. And at the end of the day, the Governor and Council will make a decision. whether to move forward with a project or not. It's no different than another End of answer inaudible. We've been told that this gives more certainty. It gives more certainty to entrepreneurs for projects under Schedule 1. I'm saying it's full trust and full confidence because projects are being almost pre-approved. We know, the entrepreneurs know that they won't need certain authorization. Usually there are rules and regulations to be studied and followed. What will be the case for public servants who will have to study all these, knowing that projects are, in fact, pre-authorized under this bill? If a project is designated as pre-authorized, do you think public servants will be motivated in their work in analyzing these projects? I believe yes, and perhaps the second highest ranking member of the public service could answer. Projects with Transport Canada, Natural Resources and current departments. Now, it'll just be a front door. They'll work with Transport Canada, that they meet after the front door, and then they'll study the project, and then there'll be an analysis done by experts in market diversification. Then it will move to the Major Projects Office. So what I'm saying is that when analysis is already done before research, then there's no point in the research, is there? Work will be done by scientists with the departments for the conditions that will be identified by the department. Thank you very much, Marcel Duval.
Next, we will go with Mr. Morin. Mr. Morin, I believe the floor is yours. Correct me if I'm wrong.
No, Ms. Stubbs is to go first.
Cede your time to Ms. Stubbs. So, Ms. Stubbs, the floor is yours. You have 5 minutes, please.
Thank you, Chair. I appreciate that. I do just want to mention, Minister Freeland, of course, we Conservatives, because we've been calling for fast-tracking clarity and certainty on all of these pieces of legislation and regulations that C5 allows to be circumvented, we would agree with your comments here today that there is a thicket of legislation and regulations that means big projects can't be built. But that is why we as Conservatives are saying those are your fundamentals to fix those laws instead of doing this workaround. But I just, and further to the point that one of my colleagues was making earlier, Canadians have yet to hear from any of you how it is that you are going to enforce federal jurisdiction on interprovincial pipelines, which are federal jurisdiction, which of course you've failed to do before. But as a person who comes from Treaty 6 and is proud to represent and work with 5 First Nations and 4 Métis settlements in my area, all of whom are involved in both traditional and clean energy, and who are the service suppliers and contractors to the oil sands, and also as a descendant of the Broken Head Ojibwe First Nation from Manitoba, I too am concerned about this government's ability to fulfill its duty to consult so far through this legislation. What's concerning, Minister, is you talked about 3 different levels and layers of approval, which is obviously uncertain in itself. And I'm glad to hear that C5 is promising capacity funding for the meaningful participation of Indigenous communities through this process. I would note that was also promised through C69. And every time I ask the Indigenous leaders and workers and proponents and private sector owners and operators who, as you know, in Alberta for decades upon decades have been earning their own source revenue for energy development, they say none of that funding ever flowed. So I sure hope that you guys will keep your word this time. But I think that it really is incumbent upon you to clarify exactly how that duty to consult will be deployed by the actual decision makers, since the court are clear that's what required is the two-way dynamic to address the to mitigate adverse impacts on affected communities. And I particularly ask you this question in the context of yesterday's AFN National Chief saying C5 will be an open invitation to court challenges and go all the way to the Supreme Court. So for all of us who want to get to yes in a good way, how will you actually make clear to Canadians that for the first time you will actually fulfill the duty to consult fully and completely, and make that be able to happen given the differences in views among the 600 plus Indigenous communities in Canada?
Thank you, and thank you for the question. So one of the challenges is having a single definition for Indigenous consultation, because, like you mentioned, there's 600 different First Nations, there's Inuit, there's Métis, and so we want to make sure it's meaningful and adequate, and so having that single definition doesn't work. It's also important, it's very fact and situation specific. So for the projects contemplated under this bill, it would depend on the nature of the project, which Section 35 rights holders may be impacted and to what degree, the nature of the Section 35 rights that may be adversely affected, and there's a number of other variables.
Thank you, Minister.
And these ones are affirmed by the Constitution.
Yes.
We've got the Supreme Court. And then this legislation in particular references in the preamble, Section 5.7, Section 7.2, Section 8.3. Those are all required to have to consult with Section 35 rights holders.
Right, and Minister, which has not been done to date, we learned yesterday, but also the bill does set up the cabinet ministers as the decision makers. So will cabinet ministers be at the table on those projects as you go through this specific project by project ad hoc, obviously inherent uncertain consultation? And also, Minister, you yourself mentioned the removal of projects from the national interest list, which you can imagine is deeply concerning, certainly also to Indigenous proponents of, for example, pipelines that got vetoed in the past that they were relying on, or LNG projects that got killed in the past that they were relying on, and had spent years negotiating with big companies in a good way to get benefits for their communities. How can Canadians and Indigenous people who all want to get to yes in a good way on these big projects trust the claims here?
Yeah, thank you. So for that one, that's Section 8.3, so page 12 of the legislation. So if a project is going to be removed, again, there's the requirement, the consultation, and the duty to consult with Indigenous rights holders who may be impacted. So,
but then you can imagine a project proponent getting all the way through and then being told no. And also, then why don't we just start with all the Indigenous-backed projects in front of the regulators right now and fast-track them?
And thank you very much, Minister.
Thank you very much, Mr. Chair. Yesterday in committee, we heard a constitutional expert, David Robitaille, who insisted very strongly that the definition of in the national interest does not at all match the Supreme Court's definition of in the national interest in its rulings, especially with regard to the carbon tax. When something is designated as being in the national interest, does that mean that it's in the general interest of Canada? But how is it that you've set totally arbitrary criteria which don't match the Supreme Court's criteria and definitions? Answer. Thank you for your question, Mr. Barcelou-Duval. I don't feel that our criteria are arbitrary, given that they are part of a bill before Parliament that will be voted on by parliamentarians both here and at the Senate. Now, there is a case at the Supreme Court on another matter, so there's not a one-to-one equivalency with this legislation before Parliament. In the majority of cases, if not in all cases, this determination will be made based on the result of consultations with provinces and territories. I feel strongly that premiers of provinces and territories, were they to come to us with a project that would affect many provinces and territories, I would approve it because it would be in the interest of many provinces, for instance. Sure, I understand the example you bring up, but what I'm saying is that there is no definition of in the national interest in this bill. The definition you do have is very arbitrary. The only thing we find is at 5.6, where it says the minister can consider, can meaning it's not mandatory, unless you're willing to amend this, and that's one of the amendments the Bloc has tabled today. Well, I'm in no position to speak to the amendments moved here in committee. I leave that to you and your colleagues in this committee. As for the criteria we will use to deem that a project is in the national interest, our criteria are clearly set out in the bill. As my colleague said, you're very lucky because you've had the criteria read to you no fewer than 2 times. Yes, thank you, Minister. I know where to find the criteria.
You have 5 minutes, please, sir.
Thank you, Chair. And I just want to congratulate the minister on her appointment to Mr. Alty. Many First Nations often rights get kind of it's hard to understand for First Nations when it comes to Section 35 treaty rights, the umbrellas under that when it comes to how provinces have jurisdictions in certain areas. First Nations traditional inherent rights are mixed into Canadian law. Treaty First Nations have long held that Natural Resource Transfer Act violates treaty rights, particularly Treaties 1 to 11. I'm wondering if the minister agrees with First Nations rights holders in this regard.
I'd have to look into that further.
Does the minister agree that resource revenue sharing, when it comes to major projects and natural resource extraction, is a model to agree with that model of resource revenue sharing from the federal government?
I know in the Northwest Territories that's an element, but I'd have to look into it further. As you mentioned, new to the portfolio, so look forward to discussing with you further.
The government has cited $40 million in consultation engagement for First Nations. Typically, we've seen a lot of spending on third-party consultants, $20 billion plus in consultants from the Liberals planning to spend $1,400 per family. For this particular instance, can the minister guarantee that the $40 million will go directly to rights holders, Indigenous communities, rather than third-party consultants?
Thanks for the question. So it is for Indigenous rights holders. I know in my jurisdiction that, or in my territory, that some rights holders then go to hire consultants, and I wouldn't be in the position to say rights holders have to hire somebody full-time on their team. If they are going to hire a consultant to lead their work, that would be up to the rights holder.
Thank you, Chair. I'd like to pass the rest of the time to the member, Jamie Schmel.
Thank you.
Thank you very much, Chair, and thank you to my colleague, Billy Morin, for the time, and congratulations, Minister, on your appointment. Look forward to working with you. Minister, we've had a number of nations here in the capital raising awareness of the fact that they were not consulted on Bill C-5. In particular, the Anishinaabe Nation First Nations, the Grand Council Chief, has said she has not been consulted. We have a number of others that are saying the same thing. First of all, did you have any involvement in the consultation? I believe some are saying they've been given 7 days notice on this. Were you involved in any of the consultation, especially with this nation? And is that the plan going forward, that 7 days notice is adequate consultation?
Thanks for the question. So the project was led by another department, and there was a number of organizations, not only Indigenous rights holders, but also national Indigenous organizations that were engaged on the legislation. Moving forward, the legislation has a two-part, I guess three-part, if a project was to be removed on the consultation. So listing a project in Schedule 1 involves consultation with impacted Indigenous rights holders. The second part, if a project would be
maybe if I could just cut in there, because in your answer to Ms. Stubbs there, you talked about meaningful consultation has to be adequate, but there were no definitions to that. And we're seeing nations here say 7 days. Is that the definition of meaningful and adequate?
Yeah, so as I mentioned, the meaningful and adequate consultation is fact and situation specific. So some of the work that our department has been doing over the past year has been working with Indigenous rights holders as well as national organizations on developing protocol guidelines for the federal government. Outside of that, I do know First Nations, Inuit, Métis also have protocols and consultation guidelines, so we'd be looking to engage with the impacted Indigenous rights holders to make sure that we are...
So what about those that are in favor of projects? We have a number of Indigenous communities that are in favor.
Exactly. So when we're consulting on whether to include a project in Schedule 1, as well as the consultation once a project's added and the conditions, we'd be working with those Indigenous rights holders. And we have Indigenous proponents that want to bring forward projects under this bill.
Okay, so that's good if they want to bring that forward. But how do you still deal with the fact that C-69 is still in place? I know this bill gives extraordinary powers to the government, but at the same time, you still have some pretty powerful impediments to development in place right now?
A very short response, please, Minister.
Yeah. So the legislation for the One Economy is listing a project in Schedule 1 as well as putting the conditions. We engage with Indigenous rights holders, consultation and accommodation. So it would also, if we were removing a project, again, the consultation and accommodation would occur.
Thank you very much, Minister.
Thank you. Just point of order, Mr. Chair.
Mr. Kellaway still has 1 minute, 50 seconds.
I would just maybe just really quickly, if we could just have Ms. Kazan add, if the minister would be willing to stay for 1 more minute. I was going to ask for 4 hours more, but just 1 more minute so Ms. Kazan could ask 2 more questions.
Any objection from committee members? Seeing none, I'll turn it back over to Mr. Kellaway, who still had 52 seconds left.
Okay. Minister Alty, one of the acts of Parliament listed in Schedule 2 of the bill is the Indian Act. Can you explain the reasoning behind including the Indian Act as one of the pieces of legislation that may need parts of it to be suspended for a specific project?
Thank you, and thanks for the question. When moving forward with projects, some communities are subject to archaic provisions under the Indian Act, and so we will engage with First Nations partners on projects, and if we need to suspend some provisions of the Act, like financial clause, leases we've heard about, we will do so in a way that allows for development while respecting cultural practices and environmental standards. But we want to retain this option for where it makes sense to advance a project, but it's after consultation with First Nation communities. So using this legislation on sections of the Indian Act may be beneficial, which is why it's included, but it would only be done in consultation with First Nations. Thank you.
Thank you, Mr. Kellaway, and thank you, Minister. And we'll turn the floor over to Ms. Kazan for one last question of the day. The floor is yours.
Thank you so much, and thank you to everybody that has come, all the ministers that have come here today. I just wanted to, Minister Alty, you spoke about the FPIC and it being confusion. Because we've signed on to international law, I just want to point to the UN expert mechanism on the rights of Indigenous peoples that we've agreed to uphold as FPIC, so we shouldn't be confused at all. But I just wanted to ask, are you aware that the federal government spends between $500 to $1 billion a year annually fighting Indigenous peoples in court, and that ITK, AFN, and NAN have indicated that Bill C-5 is an ungracious invitation to the Supreme Court, meaning that the goal of this bill to be nation-building projects will actually be an economy-killing, job-killing bill, because any projects going forward, it's becoming very clear from constitutional experts are going to end up in court. Are you aware of this? Any one of you can answer the question.
Thank you. So I would emphasize the purpose of this bill is to get approval of good projects, and we know that failing to meaningfully consult with impacted rights holders will not speed up the approvals and will actually lead to the further delays in the courts, which is again why the preamble, Section 5.7, Section 7.2, Section 8.3 all require the government to consult with Section 35 rights holders in both the selection of projects as well as the process of approving them and adding conditions, as well as if it came to the case, the projects would have to be removed.
Thank you very much.
Indicated that they haven't been properly consulted, and this will be in the courts.
Thank you very much, Ms. Kazan, for your question.
Thank you for the time.